Okay.
We're getting ready to go, everybody.
For having me today. I appreciate the invitation and I appreciate the opportunity to try and spread some information and provide some guidance. So please feel free to ask questions and to let me know what you might need from me. But let's get through some of this information so that you have a basis to ask some of those questions. But we'll start with what the probate court does and our processes in the system. I am Kelli Wolk, and I am your chief probate judge here in Cobb County. And I think, do you have the clicker? It's okay. We're going to use some words, and I try not to read the slides to you because I think that you can read them for yourselves. But once upon a time, I was asked to define the kinds of court to some young children. And the easiest way for me to define civil versus criminal court is when you're a kid and you do something wrong and your mom puts you in timeout, that's criminal. You did something wrong and you need some time to think about what you did, and when you grow up, sometimes that means that you need some time either under supervision or you need some time perhaps in a jail cell in order to think about what's happened and to improve your behavior, hopefully. Civil is when two people are fighting over a toy and a mom decides who gets it. I am the mom in that scenario, and in our circumstance, we have a situation where a family needs guidance, either in an estate situation where people are fighting over somebody's stuff, the toy, or they are fighting over the proper way to handle the situation with somebody who needs help, whether that's the result of a mental health crisis or if that's somebody who, for whatever reason, needs long-term assistance in the form of a guardianship and a conservatorship. So that's the distinction that you hear when you hear lawyers and judges talking about guardianship, civil law versus criminal law. Our probate court has no criminal jurisdiction other than if people act out in our court in front of us and those types of things. But we do not reach out into the world and enforce criminal jurisdictions and laws. So that limits us purely to civil proceedings. When we are talking about mental health and guardianship actions, the court that we are going to be dealing with is primarily the court where the person, patient, or the proposed ward resides, where they are domiciled. I call that the Disney test. When you go to Disney and someone's in line and they say, "Where are you from?" It's where you are, where you live with an intention to remain. So when you say, "Oh, I go to UGA, but I live in Marietta," you're domiciled in Cobb. You stay at UGA over in Athens, Clark County, but you're domiciled in Marietta in Cobb County because that's where you intend to remain. So the distinction between where you stay or your residence and where you are domiciled, which is where you are based, matters in a lot of our determinations about where things need to be filed and where they need to be processed. So you'll hear county of domicile, county of residence, and then you'll hear about somebody's physical presence. So if somebody's in a hospital, sometimes their physical presence is the reason that we will hear a case. So in a mental health setting, if someone is in a mental health treatment facility in Cobb County, but they live in Haralson County, they are going to have their hearing in Cobb because that's where all the records and all of the medical providers are, and that provides us with the information that we need in this jurisdiction. But we will reach back to Haralson County for certain payments and certain information that needs to be exchanged in order to make sure that the county of domicile is aware of the creation of the involuntary commitment. So Involuntary treatment is exactly what it sounds like. It is just when somebody needs help, but they don't necessarily want that help at that point in time. There was a case out of Georgia that said a person who stands as a guardian of somebody else cannot involuntarily consent for them. So I cannot involuntarily commit somebody that I have guardianship of. I cannot involuntarily commit them. Goes with parents as well. You can't voluntarily commit somebody. So involuntary treatment is a medical determination that is made by medical providers in a series of decisions that we'll go through and that are literally defined by the hour of how the medical providers have to proceed through what they're doing. A guardian is somebody who stands as a parent to someone else. That is true of actual parents who are the guardian of the person of their children. That also stands for someone who is appointed as a guardian of somebody who is an adult who is deemed by a court to be incapacitated. So legally, if they are unable to handle their affairs, meaning that they cannot make or communicate responsible decisions regarding their health and safety, another person may need to be appointed in order to make some of those decisions for them. That guardian stands as a parent to a child in the ways that are defined by the guardianship order. So if it removes the right to marry, or if it removes the right to consent to treatment, then the guardian may be the only person who can consent to medical treatment for their ward, their adult person that they are charged with taking care of. A conservatorship is similar, except it's over a person's property. So if somebody is unable to make or communicate responsible decisions about their property, then a conservator would be appointed. A very popular case of this, a lot of people have heard of a conservatorship over Britney Spears, and the court battle about that and whether or not that's appropriate on an ongoing basis. The conservatorship governs what happens with her money and her contracts and her endorsements and those types of things. The guardianship took care of her health, her safety, where she lived, all of those types of things. Those are two separate determinations. Those are two separate things that are evaluated with different standards to come up with whether it will be taken away from the person who allegedly lacks capacity and transferred to somebody else. The ensuing battle that happened in court that a lot of people were emotionally invested in came down to whether or not she had gotten to a point where she was now capable of making some of those decisions for herself. And ultimately, after a number of hearings, the court in that case determined that she was and restored her rights to her. And so that is always an option in a guardianship and a conservatorship. So those are things, that's just to give sort of a popular example, and certainly not a controlling example. And Georgia law is different than California law in the specifics of how all of that is done, and we'll cover some of that. But just in order to get some people familiar, and that's a sort of a high profile case. And then the ward is the person that's being protected. And that is a person who is an adult, who is deemed in some part or in whole to be incapacitated either to their person or to their property. So that gets us into when we transition to the mental health specific information. These acronyms, I will work through them because they are important. But please don't feel like in order to deal with the court, you need to speak acronym and vegetable soup, because you don't have to. This is just so that it sounds familiar. There's lots of numbers and lots of letters as we work through this process. I'm going to try and sort of follow the chronological process so that everybody can see from the beginning to a potential end how this process might go. In order to apprehend is something that people with personal knowledge of the person in crisis can seek. So this is not limited to family members. I hear often that people think that it has to be 2 family members. It can be 2 people who have observed the behavior. We've had law enforcement officers come and seek orders to apprehend. We've had clergy come and seek orders to apprehend. We've had family, we've had neighbors, we've had roommates. So there are lots of different people who can do this as long as they have the actual criteria of knowing and observing the behavior. So based on the affidavits, which are sworn written statements of 2 individuals who have observed behavior of the person in crisis, the potential patient, in the preceding 48 hours, which gets really scary and hanky when you start talking about stuff that's happening on Friday night. Because by the time you come into us on Monday morning, it's been more than 48 hours. So this timeline is specific on purpose, but you have to have observed the person. If they do something on Friday night and they run away and you have not seen them since then, that is a different situation. That is a different process than this. But if they did something on Friday night and continue through the weekend, and you come in on Monday morning, that behavior has continued and you have observed it within 48 hours. So that is specific and it is a prerequisite to proceeding. There has to be a reason to believe that that person is mentally ill and in need of involuntary treatment. Now, that is statutory speak. that is law speak for they need help that they're not willing to get or they're not able to get for themselves. So it cannot be that they broke their leg because a transition to a mental health treatment facility is not going to help somebody with a broken leg. So it has to be a mental health, mental illness issue in order to have the desired impact. So that's why that specifies mentally ill and in need of involuntary treatment just means that they are unwilling or unable to go for themselves. If the court reviews those affidavits and finds that that standard has been met, we, the judges, enter an order that tells law enforcement in Cobb County. We've made that arrangement with the sheriff's office. So the sheriff's office will go to where that person is believed to be, either where they reside or where they were last seen having their episode, and where they are most likely to be able to find the potential patient. And they will take them from where they are and get them in front of a medical professional. That is the purpose of an OTA. It is not to involuntarily commit somebody. It is not for protracted treatment. It is not for any other purpose but to get somebody who's unable or unwilling to get treatment for themselves or get themselves to a doctor or have insight into what their situation is, but to get them to a medical provider who can make a determination called a 1013 in order to put them into the facility for an evaluation period of 48 hours. There are designated institutions and facilities that have been listed by DBHDD, the Department of Behavioral Health and Developmental Disabilities, that are identified for the purpose of being an emergency receiving facility. So we can't just take them to Dr. Smith's office and ask for that. It has to be an approved DBHDD emergency receiving facility. Calling something a DBHDD ERF is really fun. Try and say that 5 times fast and remember all of those letters in order, and I will give you a gold star. So once they are transferred from where they were to where the doctor or medical mental health professional is, that takes the court out of it. That completes our process in the order to apprehend process. The part that now happens is medical providers evaluate the person for up to 48 hours. Sometimes they will hold somebody in order to see if they stabilize in that period of time. Sometimes they'll hold somebody to see something that they're looking for in the progression of the behavior so that they can observe that. Sometimes it takes them that long to get around to seeing somebody given whatever facility they're delivered to. If the patient is not examined by the doctor within that period of time, they have to be discharged. If they are evaluated and the doctor finds that there is a need, the doctor can execute a certificate called that 1013, and then within 24 hours, they can be transported to an evaluating facility. So they can then be admitted and transitioned to a treatment status as opposed to an evaluating status. All of this is happening on medical advice and on medical determinations, not based on a court order. That ended when they were brought through to the emergency receiving facility. Again, outside of the court's process, if somebody is transitioned from 1013 status, they can be transported on a 1014 and admitted on a 1021. That then becomes that treatment process that allows that person to be treated for up to 5 days. That requires 2 doctors. So that is when you get into people getting involuntary medications, involuntary commitment for up to 5 days. That's the switch from watching and observing the behavior to see if it rises to the level of requiring treatment. And because involuntary medication takes that second doctor, that's where we get into the 5 days and the transition of status. All of these things, again, are calculated in days and hours, not 30 days, might be a month, might be 30 days, might count weekends, might not. Because it is so short, holidays and weekends, by law, statutes 131, those are excluded because day calculations under Georgia law exclude holidays and weekends. So somebody can be held for 5 days exclusive of those days. That again, the patient must be discharged if they are not admitted for voluntary treatment, if they have not gotten themselves as a patient to a status where they are capable of saying, yes, I understand what's going on, and yes, I think I need treatment. And then the doctors are also unwilling to say that they need involuntary treatment, then they need to be released. So if the patient can't consent and the doctors won't involuntarily commit, then that person is to be discharged at this point during that 5 days. Filed in the probate court, we are back under the umbrella of court supervision. Once somebody has been held for that 48-hour period and the 5 days, the hospital has to file to involuntarily commit somebody for a protracted period of time. It is not the family that is filing. It is the mental health treatment facility under the direction of the medical director of the chief medical officer of the facility instigates that action. And that is a petition that is brought in the probate court. So we're now back under the supervision. But 2 family members or 2 individuals who have been identified by the patient are called patient representatives, and they are entitled to notice of what's going on. This is to prevent doctors from sort of shuffling patients around in the dead of night and hiding them and doing those types of things that make for really good movies and really terrible mental health treatment. So we try to make sure that we have 2 people who are known to the patient. Usually it's family members, it can be significant others, it can be friends, it can be roommates. It's a person that's designated by the patient, or the hospital can identify the closest family members if they are aware of those people. If the patient is unable to designate patient representatives and there are no closest family members known, the court has to appoint a guardian ad litem in order to represent the best interest of the patient, in order to protect them, again, so that somebody knows where they are, somebody knows what the discharge plan is, somebody knows what the treatment plan is, and what's expected in order to succeed in this treatment plan. Once that petition is filed, the court has 7 to 12 days to go through our processes and have a hearing. We always have a hearing in Cobb. The code provides for a waiver of that hearing. It is my opinion that if they are not capable of going voluntary under the advice and observation of their treatment team, that them voluntarily waiving the hearing is questionable. So we will always have a hearing at which the court-appointed attorney for the patient can decide whether or not that patient attends, because these can be traumatic for somebody. They can be, it can actually be against the ward's position. They may not be able to present themselves in a way that will convince the court that they should be able to go home. And their attorney should be able to work with them and decide to waive their presence if they choose to. But we are not going to waive the hearing based on a consent from somebody who is alleged to lack capacity to make those decisions and is an immediate threat to themselves or others. So we give notice to the patient and to their patient representatives. We'll call them family, but understand that they don't have to be family. Those patient representatives or the guardian ad litem, so that there is somebody there to report not only to the court on what the patient wants, which is the patient and their attorney, but also what is in their best interest from people who know and have had an opportunity to either know the patient or to investigate their circumstances, a guardian ad litem, and make that report to the court. So that is the purpose of that hearing, and to get that background information. At the conclusion of evidence, after we've heard whatever the hospital has to say and whatever the patient has to say, we can either discharge the patient, we can order the patient held involuntarily as an inpatient, meaning they stay in the facility for up to 6 months, or we can order involuntary outpatient treatment. We can also couple those together, where somebody may need to, say, 2-3 weeks of involuntary inpatient, and then when the medical facility and the medical professionals decide that they have attained a level of stability that they are ready to transition to an outpatient state, they can be on involuntary outpatient, which means that they may return to either a transition facility or to their residence, but they will still have mandated therapeutic sessions. They may still have medical check-ins where they receive injections or oral medications under supervision, but that will all be part of that treatment plan that's developed during their hospital stay or their treatment stay, and a condition on their discharge from the facility. That is mental health. That is the court's involvement. At the end of that process, we've entered an order, and then it is up to the medical professionals. After that, when they are discharged during that period of time or at the conclusion of that, the order requires that the facilities let us know that they have been discharged. Partly because we need to know that they were discharged, because if we get another petition on somebody to instigate some part of this process, we need to know that they're no longer being held and we're not talking about a different person. But we also need to know that the facilities are complying with our orders so that we know that they are getting the treatment and the respect in the process that they deserve, because sometimes that gets overlooked and it causes concern about what other formalities may or may not be being subscribed to in the process. So that is the mental health side of things. That is outside of the control of the family once that initial order to apprehend affidavit is submitted to the court. Another tool that is frequently used in mental health cases is guardianships and conservatorships. A guardianship and a conservatorship, as we discussed, is an adult who is in need of someone to help them take care of themselves or their stuff. It is a petition that is filed by either, and I think that this is a funny way of putting it, two individuals with personal knowledge of the behavior, or a person and a medical professional, who apparently is not a person. But they are a person, but they have expert opinion on this person's need, as opposed to family relationship and exposure that you may have with somebody who's lived with them or has a close family relationship with them. So they have different standards that they provide, and they will submit an affidavit in support of a petition brought by one person, as opposed to joining in the petition itself as a second petitioner seeking the appointment of whoever is deemed appropriate by the petitioner. So the doctor, social worker, psychologist may not have an opinion as to who is the appropriate person. They just are making a medical determination that this person needs this assistance, and then the petitioners come forward and nominate someone to serve in either or both of those roles, and that is what is presented to the court. The legal standard, again, is lacks sufficient capacity to make or communicate significant responsible decisions concerning health or safety and management of the property. That is the guardianship and then the conservatorship. The process begins with the petition. It is filed with the court. The petition needs to be complete. It is long. It is a lot. I've had lawyer friends when I was practicing attorney who said, I'm just going to hire you because this is 27 pages and that's stupid. But we are looking to take away somebody's right to decide where they live, to marry, to own property, to enter into contracts, to make decisions about their health care. It's not something to be taken lightly. The probate judges, counsel, and the probate courts have made a commitment to try and make our courts accessible to everyone. So this is a compromise. It is a sophisticated relief that is being sought. It is a huge imposition and a huge impact on a person's life. So you have a compromise of a difficult 27-page petition to fill out, and you need to know that you are filling out every line, or that you are choosing not to fill out a line for a very good reason. But leaving blanks is going to cause questions for the court in certain spots in the petition. So make sure that the petition is completed and all of the information is provided. Also make sure and read all of the initial instructions that come with the form. And then within each paragraph, there are internal instructions. Some of them say things like required, and then give you instructions. That means you have to write something there. So if you don't write something where it says required, you can pretty much know that we're going to need more information about that particular question. So read all of those instructions as you work through the petition. Once the petition is filed, assuming that everything is in order, and we have all of the facts and support, and under paragraph 13, we know that this person resides in Cobb County and we have proper jurisdiction of this person, and that they are either found here or they're domiciled here, and all of those I's are dotted and T's are crossed. Since this is a significant legal proceeding, the court will proceed to appoint an independent evaluator. It will be a doctor, a psychologist, or a licensed clinical social worker in order to perform an independent evaluation. This is a staple of Georgia's attempts to protect our wards, because we don't want petitioners coming in and nominating the evaluators, because we don't want the situation in the system rigged in anyone's favor. So the court works with a staff of, or a list of people who have worked with the court. They're familiar with our processes. They've testified with us before. They've seen processes. They've seen successful and unsuccessful petitions. So we appoint one of them. We also appoint an attorney for the ward. Again, when we remove rights from people to walk around because we're sending them to jail, we give them an attorney. We should be providing attorneys for taking away even more fundamental rights like getting married, deciding where you live, owning property. So we appoint an attorney on all of these cases. The petitioner is the one who is responsible for proving their case. That means they have the burden of proof. So they need to show that there is an actual need for this guardianship and conservatorship. And then they need to show who is the appropriate person. Because I may petition for appointment of guardian over my mom, but I may have a situation in a history with my mom that makes somebody else a more appropriate person. It may not even be intentional. It may not be that I've stolen money from my mom or I've beaten up my mom or something like that. It may be something as simple as I stress my mom out because I'm a perfectionist. Which I might, but it is important that the best person for the job is the person who is nominated, and if not nominated, determined by the court through this process in order to make that recommendation and try to find that person. If a guardian is appointed following that hearing, certain rights are removed from the ward and transitioned to somebody else. This is the distinction between what you may have heard of as a guardianship and a power of attorney or an advance directive for health care. An advance directive for health care, or what we used to call a living will and a power of attorney for health care, is where I, as a person, grant somebody else permission to do stuff for me if I want them to. It is revocable. So doctors are always going to want my consent for treatment if I am capable. If I am incapable, an advance directive comes into effect because I'm under anesthesia, I've been in a car accident, I'm incompetent, or I'm unconscious, or whatever the situation is, and I have asked that person to stand in my place, kind of like hiring a lawyer or hiring a plumber or hiring a yard guy, because they can do things that I can't do in that circumstance because I'm unconscious on a table. A guardianship removes those rights from me and gives them to somebody else instead. So I may be standing there making decisions that are not in my own best interest, like wanting to sell my house to my neighbor for $25, which will cause a very serious hardship on me. I have seen cases where people liked making people happy, so they went down to the local gas station and pulled money out of the ATM, as much as it would give them, and handed it out to people because it made people happy. That was not a good decision for them. They were not going to be able to provide for their well-being. We removed their right from them rather than allowing them to identify somebody who could act as well, because a power of attorney does not remove my right to go down and make those bad decisions, either sell the house or give away all of my money, or to act in a way, not eat, for example, that might harm me. So that's the difference between removed rights and concurrent rights that are granted under an advance directive or a power of attorney. The additional authority that's referenced in this slide allows for a guardian or a conservator to do additional functions, move somebody outside of the state, which may in fact have an impact on inheritance rights, because if they move out of the state, it may change their domicile. If you move to California and you're married, you may have a right to half of the property if you're the spouse. You don't have that right in Georgia. So you're fundamentally changing the property rights of the person by moving them out of the state. So we have restrictions on moving somebody out of the state, not within the state. So that's an additional authority that has to be requested before it is effective in changing the domicile of the ward. Every year, a guardian has to file a personal status report. That's how we find out sometimes that people have moved their wards. We find out that somebody might need a change. I often hear, I became my son's guardian. I'm now 85. I have health concerns of my own. I need some help. I think it's time for somebody else to be in this position. I would like to have, and that starts a process that we can investigate. The personal status report is pretty simple, but it gives us some basic information about the status, location, medical well-being, and recommended changes of a guardianship. It has to be filed every year, but there has to be an initial one filed within 60 days after the creation of the guardianship. There is a grace period of 60 days every year so that you can put the report together and get it to us. So it's due, if you were appointed on January 1st, we need the report as of January 1st, but you have 60 days to put it together and get it to us so that we have that grace period. Conservatorships have to file an initial inventory and asset management plan within 60 days. That is a heavy lift sometimes, to barge into somebody's financial life and figure out where all of their assets are, what the balances are, what the condition of the estate is in 60 days when somebody's not able to give you that information. We know that. We look for the best information that you can get with supporting documentation so that we know that you're giving us the best information that you have. And then we ask for a budget. We don't ask for it, the state requires it, but we like to say it's an ask so that it sounds nicer. But there is a budget that is required. They don't call it a budget because it's law, so they call it an asset management plan, so we affectionately call it an AMP. And the budget is a forward-looking document for what you expect for the upcoming year to cost. So if somebody rents an apartment at an assisted living facility for $5,000 a month, meals are included, whatever, they have $100 a month for hair cuts and certain medical supplies like lotions and Depends and shampoos and soaps and all of those kinds of things. You may have $5,500 on your monthly budget because that's what you expect the next year to cost. That is an educated guess given what you know of the upcoming year. I don't know about you, my budget doesn't always reflect what actually happened in the preceding year, but that is your best guess, and that is all we are looking for in that initial budget is a realistic guesstimate of what you anticipate will be coming up. That is the beginning of the guardianship process. And then on a maintenance, after that first year, you will file an actual report called an annual return of what occurred financially for your ward. So you'll have the looking forward budget every year, and you'll have the looking backward return due every year, which is frequently confusing to people when they're trying to file them because they think, I filed this, it got approved, now I spent that money, why are you having me tell you something different? If you're telling me in round hundreds of dollars what you spent last year, you're doing it wrong, because I need to know you spent $182.79 at Walmart for supplies in the preceding year, because that's what you actually spent, not that you estimated you'd spend $200. So we need actual numbers in the backward-looking document and good faith estimates for the forward-looking documents. Some documents that you may have heard about that are relatively new in Georgia are psychiatric advance directives. Psychiatric advance directives are sort of what you might consider as a springing document that are held in reserve while someone is functioning well, but may anticipate, due to a diagnosis or a history or both, that their condition may change and they may need some assistance and advice in the form of an advance directive, so that there is someone, when they are in crisis, that they can have in place to deal with their mental health providers. So if somebody has a bipolar diagnosis, for example, and they are fully manic and they get taken into a facility on an OTA, which you now know what that means because you've heard the acronym, but if they get taken into a facility on an OTA, the person who's operating under that psychiatric advance directive, known as the agent, will be able to communicate with the facility, and it's not as easily revoked while they are medically deemed to be in crisis. Because what happens a lot of times is, if somebody is in a mental health crisis and they are paranoid or they are psychotic, they may fear the person that they've nominated and tear up the document. So this was developed in anticipation of somebody who is in a good place needing to appoint somebody in anticipation of decompensating in the future and having that in effect when they don't have the ability to make a competent decision to revoke that document. The information and all of the parts are outlined at the Georgia Legal Aid website, which we have here on the slide, so I'll direct you to that if you think that that fits your needs. And sometimes it's necessary, much like other tools, that you sort of put a few of them in your quiver, and you may end up needing to stack some of these tools together in order to work through what you have and what you need when things start to get rough and bumpy. I understand that we have some questions from the audience that were submitted, and I'm happy to take some, but thank you. Thank you, Vanna. Can a person under a conservatorship vote? Presumptively, yes. The one of the rights that can be removed under a guardianship is the right to vote. It is not automatically removed, and it is only removed when there is a specific showing and a specific finding that a removal of that right would be appropriate because that person is unable to vote. And there are lots of people who specifically request that they retain that right in order to vote, and typically, unless there's a reason not to, we leave that right with them. And if we do remove that right, we have to notify the Secretary of State's office in order to make sure that the voter rolls are handled appropriately and all of those types of things. Another question that I have is, I have a guardian and a conservatorship for my older brother in South Carolina. If I need to move him to Cobb, do we need to go through this process that you have outlined? He's 68, mentally ill, he is mentally ill in teens? Okay. All right, so typically I'm going to proceed with he is 68. And so there is a provision, and it's called the, it's UGUMPTA, the Transfer of a Guardianship Act between states. There are, I think, 4 states that have not passed that unified act, which allows transfer between states. One of those states is Florida, and then there are a couple others, and I'm drawing a blank on what they are. So Tennessee, I believe, is a state that has passed that. I always have to look just to make sure, because I always want to be sure. But we would, if somebody wanted to move from a state that has passed that unified act, they would institute the transfer from the home state where the guardianship started, and ask us to receive that guardianship. We would then communicate with the guardianship holding state, in this case Tennessee, for them to enter an order that preliminarily ends their guardianship once we start ours. It's the most elegant way we have been able to make laws that get us to essentially a relay race of making sure that there's no gap in protection for somebody who has a guardianship. So that is the process. Then when we enter our order accepting that guardianship and or conservatorship, we send notice to the Tennessee court or the other court, and they then officially terminate based on the creation of our guardianship and conservatorship. And then all of the reporting, all of the information flows through the receiving court, and that becomes the court overseeing that action going forward. If you are coming from a Florida, or I think California has passed it, but they don't always honor it, and so we won't get into that, but let's use Florida where they haven't passed it. Then the best thing that we know to do, because there used to be a provision that governed what to do in these circumstances, but it was revoked or repealed when they passed the Unified Act, because it never occurred to anybody that they wouldn't pass it everywhere. So they revoked all the provisions for what you do if there is not the unified bill in the home state. So the best thing that we have been able to come up with is that you file an action to initiate a guardianship and or a conservatorship here, notify us of the pending guardianship and conservatorship in the other state. We then reach out and we deal with instituting it and making sure that everything's in good standing in the home state and begin that process. And then once we get it here, we let them know, and we sort of informally do the process that has been done in the unified states. So hopefully we may need to jiggle that a little bit and adjust it depending on the status of the other state and the willingness of that state to accept a quasi-transfer. But for the most part, if they've authorized you to relocate the ward here, either before beginning the process of moving the guardianship or as a condition of moving the guardianship, sometimes they'll say, we know you want to move to Georgia, go ahead and start that process, and then when you get it all set up, then we can transfer it. So that is how we have handled it in the past. But it happens enough that we know that we have made it work, but it is not really anticipated. I've talked to the folks who wrote the Georgia version of the unified law, and we asked them, why did you take out this previous provision? And their words were, because we honestly didn't even consider that the unified law wouldn't pass. Can I have those? You're fine. You're fine. How long can a child be before you can file for a guardianship? So if we are talking about a guardianship of an adult, it can be instituted at 17 and a half so that the procedures can begin before they turn 18. Again, we're always trying to avoid that lack in coverage. So when somebody is 18, if it takes us a few months and they have a crisis, either a mental health crisis or a medical crisis, they may not have somebody who can consent for them in that void. So Georgia began a number of years ago allowing the proceedings to begin at 17 and a half. We try to match up the actual hearing and the issuance of an order and letters as closely as we can to 18, because we found that sometimes there are other orders like custody arrangements in divorces and those types of things that if we issue our orders too early, it causes confusion sometimes for law enforcement when there's an overlap of a few months where we've told everybody in court that this will not take effect until they're 18, and we issue you your letters of guardianship and conservatorship, but they'll still hold up an order that was issued 2 or 3 months prior to. And so we have instituted where we're trying to sort of nicely marry close in time to that 18th birthday so that it's cleaner for everybody, but 17 and a half. There are other provisions that deal with guardianship of minors that are simply for arrangements because there are parental agreements and situations, or if there's a need for a removal of parental rights on a permanent or temporary basis, but those are handled in other courts, either juvenile court or superior court, depending on what the structure is and what the situation is. So what happens if I haven't seen my child's father in a long time and he doesn't pay child support? Do I have to notify him if I file a guardianship over my developmentally disabled adult child? Yes. If they have not had their parental rights terminated, then we need to the best of our ability, give notice to that legal father in order to avoid confusion on the back end. That old saying, rip the Band-Aid off and call the question, is an important one because, not because we want to make things difficult, but because we are removing rights and we are transferring them to somebody else, we need to give notice to everybody who would be entitled to object on the front end. We will ask for a due diligence statement. What have you done to try and find this father? We have had fathers, we've had parents, both mothers and fathers, who have been deported and have had no contact with their family for decades, where they legitimately don't know where somebody is. We've had people who have had missing people reports on them for years, and sometimes you really can't find somebody, and that is a legitimate set of circumstances. But just saying, I don't know where he is and he hasn't paid child support, is not going to be sufficient. We are going to need to try to give them the best notice that we can. The reason being, if we don't, and that person shows up and says, and we've had this too, we've had fathers who have shown up and said, I was visiting every other weekend on my schedule and I was paying child support and she knew where I was and she just didn't want to tell me, and that threw the whole guardianship status into a mess, and we had to set it aside because it was fraudulent, because there were allegations of misrepresentations. He had filed an entire set of canceled checks and everything with his motion. We set it aside. Then we've created the exact situation that we've been trying to avoid, of having a gap, because we now have an adult who himself could not take care of things that he needed to take care of, but we have two people who are fighting, and we had to start the process and go through the hearing and do all of that because he was the legal father entitled to notice and there was a misrepresentation to the court. So it is better, I know it's not fun, but it is better to have the uncomfortable moment on the front end and deal with it when we have the time to sort of work through that process than it is to be in the middle of a situation and have the rug pulled out from under you and your ward. And remember, it's not about the guardian or the petitioner. It's about the person who you're seeking protection of and what's in their best interest. And that's the interest that we have to put in the forefront. So that's why we need to give notice as best we can to that person. Okay, I think that covers all of our questions. I appreciate everybody's time and attention. If there's anything that you need from us in the probate court, we have a great resource page on our website. If you Google Cobb County Probate Court, and we appreciate the collaborative putting this together. We appreciate TV23 for helping us memorialize it for everybody. I appreciate everybody who's here today. I appreciate my folks in the probate court who have helped me put this together, and to be here for you every day and all the time. And feel free to visit our website, and hopefully it'll help. Have a great day and be kind to each other. Thank you so much.